Hi there, I'm Stephen Wenner, and I am a broker associate over at the Whistle Beer team, powered by EXP. I've been in residential real estate since 1993, done well over 1,000 transactions, and I'm always learning. And today, I have a phenomenal guest that scared the living daylights out of me, and that's why I wanted to have him on with us. We have Mr. John Allen Enochs, who goes by John Enochs online, but likes to be called Allen, so not to confuse any of you. And it's Enochs Law Group. And he is an unbelievable real estate attorney. And the reason that I wanted to have him on today is because there were several topics that I wanted more information on, specifically if you're looking to be an investor and buy real estate in California. What does that look like? And when we dove into the conversation, which we're going to relive the conversation with you so you have knowledge, information, and power, you're going to recognize how many steps need to go into protecting yourself or understanding what the process is like and some of the pitfalls that you may need to prepare for regardless of what happens. And we're just going to have a robust conversation on several things. But John, I want to start by just enlightening everybody. And when you and I had the opportunity to sit down and you started making me aware of what are all of the things that a potential landlord needs to not only be aware of, but the things that they need to put in place, like pamphlets, disclosures, things of that nature. I'd love just a quick rundown of what does that look like in California?
So we represent real estate investors. That's the crux of our law practice. We value the entrepreneurs of the world, and as such, we tend to target them as clients. That's the group that we tend to represent. That includes real estate lenders, that includes people buying various types of properties, people buying to fix and flip, people buying to hold. What we're talking about now is the single-family residential space. When we talk about the single-family residential space, the first thing that I share with my clients as they come in the door is California over the past 6 years has substantially infringed upon private property rights relative to single-family residential properties that are non-owner occupied, meaning they're intended to be rented out. The infringement has come in the form of regulation. The regulation has substantially taken place at both the state and the municipal level. When we talk about the municipal level, we're talking about the cities and the counties within which the property is located. Now, we as human beings, we like to simplify our understanding of the world and how it works. So we like to have a set of rules that we can apply across the board to all transactions because it allows us as human beings to process and analyze in an easier fashion transactions. In this particular setting, we now have laws not only at the state level but also at the municipal level. Because of that, depending upon where your property is located, the rules can be different. So it's no longer possible with all this municipal regulation that is we've seen over the past few years. It's next to impossible to create such a standard that allows you to analyze across the board these transactions. So if somebody's going to get into the investment space involving single-family residential properties, they need to be mindful of the fact that, unfortunately, they're going to probably have to hire a lawyer to get involved to make sure that they're compliant. The rules of engagement with a tenant in San Diego is different than it is in Los Angeles, which is going to be different than the way it is in Orange County, Riverside. The way it operates in the city of San Diego is going to be different than the way it operates in the city of Chula Vista, by way of example. Failure to comply with these regulations, also the penalties vary depending upon the property's location. Again, frustrating an investor's ability to simplify the process of investing in the property.
And that's when I really started to get worried, is when you were telling me, and again, was it Chula Vista that has a $2,000 to $10,000 fine per day?
Yeah, so like for example, so in both the city of San Diego as well as the city of Chula Vista, they have local ordinances that regulate the landlord-tenant relationship relative to single-family residential properties. Failure to comply varies depending upon whether you're in the city of San Diego versus the city of Chula Vista. In the city of Chula Vista, they actually impose a monetary fine. The monetary fine for noncompliance can be $2,000 to $10,000 per violation for each day the violation is outstanding.
Per day.
Per day if the violation is outstanding. Now, one of those requirements, both at the city level as well as the Chula Vista level, it requires a notice to be given to the tenant as of a specific moment in time, and depending upon whether the tenant was in place preceding the enactment of the ordinance, or it came into play after the enactment of the ordinance, dictates how and when the disclosure takes place. But failure to make that disclosure in the city of Chula Vista can result in a $2,000 to $10,000 penalty per day. Now, what is that notice? Well, the notice should have been given back, I think it was in April or March of 2022. And I have yet to speak to a landlord that's complied with that ordinance.
Right, which is scary. That's what I mean.
Which is horrible. So when the landlord calls us up on the phone, and we get these calls all the time, or and they call us up on the phone and they're upset because the tenant has been paying rent or whatever the scenario may be. The first thing that we do with them is to say, stop. We have to look at your file. We got to look at what you did. We got to look at the strengths and weaknesses of your position, because with all this regulation, if you haven't been compliant, that could affect the outcome of a dispute or a grievance with the tenant.
And let's just say, let's do a rough calculation, conservatively at $2,000 a day, something going back to mid-2024 and being caught now. Like, imagine 365 days, right, of $2,000 a day. Mm-hmm. So that's enough to bankrupt somebody. It could be sufficient to put somebody into bankruptcy, and that has happened. We're defending a lawsuit now where the tenant is coming after the landlord, and the tenant's no longer in the property, but they're still coming after the landlord for non-compliance with much of this regulation. And so then the landlord finds himself in a position where they're starting to pay money, lots of money, to a lawyer to defend them. Now then, you could try to protect yourself with a rental agreement that has an attorney's fees provision that says the prevailing party, in the event of a legal dispute, gets reimbursed for their attorney's fees and costs. But if those attorney's fees and costs are measured in tens of thousands of dollars, $60,000, $100,000, which can happen, is the plaintiff tenant good for the money, even if the landlord wins? And probably not. And so if the landlord wins the case, they go to trial and they completely defend the case. They get a piece of paper that says they're a winner, but they can't take that piece of paper to the bank and deposit it to reimburse themselves for all the money they spent on a lawyer. What they have is a piece of paper that says they can now go after the tenant who lost the case. It's to seek reimbursement for the legal fees. Realistically, what's probably going to happen is that tenant is then going to file bankruptcy themselves, and then the landlord, defendant, all he's got is the satisfaction of winning the case, assuming that he wins the case. And so now he's paying a lawyer lots of money to defend him, and his upside is he doesn't have to pay the tenant. And so we end up having to, and here's the reality of it. We constantly and continuously receive calls from our investors who own single-family residential properties, where they're getting demand letters from other lawyers saying, we don't think you have complied with the municipal ordinances relative to the landlord-tenant. We're hereby making a demand for payment. And the biggest demand we've seen so far has been $75,000.
And we had one lawyer get a hold of a duplex, and they got the tenants on both sides of the duplex as clients, and they're making a demand for each. On each to our client who owned both sides of the duplex. And so that's out there. And so then when they come to us, and then the question becomes, what do we do? And now you're spending money in order to try and thwart this assault that's coming at you. Now, we should be clear as to what's really happening. When lawyers get involved in something, what are the lawyers doing? Well, the lawyers that are on the plaintiff side, they are every bit trying to get money. And the way they get money is they set in motion a legal process that if it's allowed to reach its natural conclusion in their favor, or their client's favor, that puts them in a position to send sheriff's deputies into the losing landlord's world to interfere with his property. If there's resistance, it'd be an interference with his liberty. If they really interfere, then they'll probably be shot. And so what we're talking about, at the end of the day, all laws are enforced by sheriff's deputies. That's how they're enforced. Otherwise, the laws would be meaningless.
Sure.
And so when you sue somebody for money, and if you win, you're now in a position where you have to enforce the judgment. And the way you enforce the judgment, you send sheriff's deputies into somebody's world to interfere with their property. And you're not looking for their consent. You're not looking for permission. You're doing it using force. That's why the sheriff's deputies are involved.
So the form that you mentioned, came out a few years back. First of all, what is the form that has to be given to a tenant just for the initial?
You have to look. It depends upon the municipality.
Okay.
And so you have to look at the municipal code to look for the language. Like, for example, I think it's the city of San Diego or city of Chula Vista. It might be the city of Chula Vista. Actually specifies the font size that you're supposed to use.
Wow.
So you have to be careful. Some of the regulations and some of the transactions. Now, this isn't landlord-tenant specific, but for example, the Home Equity Sales Contracts Act that deals with buying properties that are in foreclosure, that not only specifies some of the language that needs to be within the contract, but it specifies the font size, and the location of the disclosures in the text that are in there. If failure to comply subjects the violator to substantial penalty, and they have all these protectionist laws that we're talking about here. They all have built-in attorney's fees provisions that say if the tenant prevails, the landlord has to reimburse them for all these legal fees, which incentivizes lawyers to take them as clients and then go after property owners.
Do you also find that, well, let me back up the question. This is going to go out there, it's going to inform a lot of people and educate a lot of people.
Mm-hmm.
Now you've got a landlord out there that goes, oh my gosh, I probably didn't do that. And they want to go back to their tenant. What do they do? Because now you're all of a sudden notifying your tenant that you didn't do something that has a monetary ramification. So it's kind of like, how do you get stuck in all of that, or what do you see?
That's a really good question, and we do get those types of questions frequently. What we typically do is we say, okay, let's look at what you did. Mm-hmm. What didn't you do? And based upon the penalties that are associated with it. Critical thinking comes into play here. We have to look at what is the position that the landlord occupies, and what are his alternatives to get out of it. Mm-hmm. Now, doing nothing is always an alternative, but that doesn't mean it's a wise alternative. No matter what alternatives that we're looking at and we're formulating, every alternative is going to have a cost, a benefit, and a risk associated with it. And we always include the alternative of doing nothing so they can compare the cost, benefit, risk of doing nothing to the other alternatives. So, for example, if one that's a tough pill for landlords to swallow is when they come to us and they say, we're having a problem with the tenant, we need to regain possession of the property, we need to terminate the tenancy, or they're not paying rent, or whatever the situation may be. Mm-hmm. One of the first alternatives we throw out there, not the only alternative, because you can always fight them, or you can try to persuade them in some fashion.
Sure.
But we say, on the persuasion side, do you offer cash for keys?
Right, cash for keys.
Cash for keys. You have to, and as unpleasant as that may be to pay a tenant to voluntarily leave, you have to compare that alternative
Right.
to the cost of paying a lawyer. And oftentimes, the landlord can get out of the problem by paying the tenant cash for keys for a dollar amount that's far less than what he's going to pay the lawyer to
Right.
use legal force to get him out of the property. As unpleasant as that may be. Now, something as well, in terms of some of the municipalities have really gone crazy with relocation assistance.
That's what I was going to ask. Anyway, I'll let you discuss that because that one boggles my mind.
Yeah, so people in Sacramento, as well as at the municipal level, have adopted this idea, this proposition they've started to advance. And the proposition is that housing is a human right. But their thinking never goes any deeper than that, other than to say housing is a human right. But when you start advancing a proposition like that, then the laws that you pass are going to flow accordingly. But what goes into housing? Well, housing, there are materials and there is labor. So when you say housing is a human right, you're saying you have a right to another man's labor, and you have a right to another man's property or materials, and which in turn are produced by somebody.
Sure.
And so, as a consequence, you get a lot of regulation that comes into play that's interfering with property rights. Now, housing is a human right. Well, if it's a human right, therefore, what can we do to guarantee that the tenants have housing? Well, if you're going to terminate the tenancy, well, doesn't it make sense then, if housing is a human right, that you, the landlord, pay to relocate that tenant? You cover their expenses associated with the relocation. How much do they have to pay? Well, that's a good question. That depends upon where the house is. And so when we get these calls that come in, I say, well, where's the house? we will frequently ask, where's the property located? Because the amount of relocation assistance is going to depend upon where the property is located. The amount of relocation assistance that has to be paid if they're located in Chula Vista is going to be different than it is in the city of San Diego, which is going to be different if it's in El Cajon or versus Los Angeles. So the first thing we have to ask is always where's the property located? And then we start looking at the municipal code as well as state law, but the municipal code is the one that's the most challenging and is changing most frequently.
So how does that work? You mentioned terminate the tenancy. What if a lease naturally expires?
So that's another good question. So so you can terminate the tenant. There's what's called just cause fault evictions and just cause no fault termination of tenancies. And so where we're seeing a lot of problems today within the city of San Diego is in the realm of no fault just cause terminations of tenancies. Because within this, just like in Chula Vista, with the city of San Diego, you have an obligation to provide a disclosure to the tenant as to what their rights are under the municipal code. Failure to comply with that has consequences. In Chula Vista, it could take the form of monetary penalties. With the city of San Diego, it can result in the landlord not being able to terminate the tenancy for no fault, just cause.
So, layman's terms, no fault, just cause means
that means the tenant is paying rent, but let's say the property owner wants to sell the property, or the property owner wants to move into the property, or wants his children to move into the property, or something of that nature.
When the lease is expiring, correct? Or at any time? Yeah,
well, you have to look at if it's during the tenancy of the lease, that you have to look at termination rights. Where are they with respect to the lease? But let's assume that the lease has matured, and the tenant's been in the property for more than a year. Well, okay, you have a right to terminate the tenancy if you're going to take it off the marketplace. But if you didn't send that notice under the municipal code, For the city of San Diego, nope, that, the tenant, it's discretionary with the tenant whether he's going to remain in the property or not. And we got cases where it's on failure to disclose, where the property owner buys the property anticipating taking possession of the property, but then where there's a tenant in the property and the tenant hires a lawyer and says, nope, 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 we get to stay here. The seller didn't provide us with this notice, and look at the municipal code. Housing's a human right. We have a right to this housing, and then now you have a fight. Now we have to separate the economics of a conflict from the merit of a conflict. It is completely possible to win a legal conflict on merit, but lose economically. Mm-hmm. So that's what I was referring to earlier, because anybody that enters into a conflict should be paying attention to their bank account. And they should measure success not by who gets a piece of paper that says winner or loser. They should measure success by the minimizing the detriment to their bank account.
Right.
And so it can be quite expensive to take a case to trial and win, but if you can't get reimbursed for what you spent getting that piece of paper that says winner, then you're going to have to look at your bank account and compare the detriment that your bank account sustained in comparison to what you could have gotten out of the case for at the front end on a cash for keys or on some sort of upfront settlement with the tenant. And the problem that we're having right now as a society are the lawyers. The lawyers I'm a lawyer, and I'm going to throw lawyers under the bus. Lawyers are the ones that created the law, and the lawyers are the ones that are capitalizing off of the disputes. It's not the defense lawyers like me that are out there initiating the conflicts. We're responding to them. But there are a lot of lawyers out there that are out there initiating conflict. They know that their client, if they lose a case with a landlord, they're just going to roll their client into a bankruptcy because they don't have much to begin with. So that means they can be as reckless and irresponsible as they want to be in advancing these lawsuits against property owners. And then they essentially are putting the property owner in a position where it's cheaper for the property owner to settle with the tenant than for the property owner to pay a lawyer to defend it. And I call that a shakedown, and that's exactly what's happening.
And that's what it sounds like. And I wanted to shift gears for a second and just talk about, sometimes people will ask me about specific areas of San Diego. And I have to be very careful, the term steering, right? Not to steer somebody or to be discriminatory about specific areas. And we have to be very careful of that. But as a landlord, sometimes first responders or military or certain people want to bring in certain people, right? That they might have some commonality with, which is also now considered discriminatory. So I just wanted you to talk about some of those things and how people can, I don't know, like you had mentioned before we started the interview, there are certain questions you can ask, or I can't remember how you framed it, but you basically said it's not so much what you ask, but it's what you do. So there were different, there are different ways to go about things maybe if we have preferences, but we can't just blanket put it out there and say things that are now considered discriminatory, because now you're blatantly in violation.
Well, here's my response. The problem that we have as a society is the laws change all the time, daily. I spend an ungodly amount of money every month having access to the law, the legal subscriptions. I pay third parties to monitor what's happening on a daily basis to keep up with all the changes in the law. And I can go into it and I can see what's happening. But the average person doesn't have that flexibility. Sure. So whatever I say today may not apply tomorrow. Okay, so when we and there is a movement, because remember, housing is a human right, right? We as a society have adopted the proposition that housing is a human right. And so therefore, we're going to do what we can to make sure everybody has housing. Now, I don't agree with that proposition, but that's what we as a society have advanced. Now, One way to do that is to make sure people have housing is to restrict a landlord's ability to deprive them of housing.
Right.
What would incentivize a landlord from depriving somebody of renting his property? Well, do they have a history of suing landlords? Do they have a history of forcing landlords to go through legal proceedings to evict them? Are they employed? Do they have income where they can meet the lease payment every single month? Do they have money in the bank? Do they have other assets? There is a positive correlation between the financial well-being of the prospective tenant and their ability to meet the lease payment every single month. So from a landlord's perspective, he wants to make sure that he's putting somebody into the property that's responsible, conscientious, respectful to the property, and has the financial wherewithal to meet that lease payment every single month. But if housing is a human right, then we're excluding from housing those people that are irresponsible, the people that don't have the income or assets or wherewithal to meet that lease payment every single month, much to the chagrin or the detriment of the landlord. So, as in municipalities, City of San Diego as well as the City of Chula Vista have advanced propositions that housing is a human right, and they continue to pass ordinances that restrict a landlord's ability to deny those people that are less attractive as prospective tenants in the eyes of the landlord. And so the landlord has been placed now in a position where he's got to make a tough decision. Do I risk getting sued for some sort of discriminatory behavior? Or do I go ahead and do what's necessary to ensure my comfort level that the tenant that I put in the property is going to be responsible, conscientious, and respectful to my property, and they have the assets and wherewithal to meet the lease payment? I'm having to choose. And so if you're placed in that position from an investment and an economics perspective, not necessarily a legal perspective, but from an economic perspective, you have to have that screening criteria. Or now here's where I think the people in Sacramento and as well as the municipalities get it wrong, is the people that own property are productive people. They're entrepreneurs. They can invest anywhere they want.
Yep.
They don't have to invest in San Diego. They don't have to invest in Chula Vista. They don't have to invest in the county of San Diego. They don't even have to invest in California. They can invest anywhere they see fit. Mexico, they can invest in Texas. They can invest in Florida. World's their oyster. They can go anywhere they want. And they are. They are because of this. And so the people that are now coming in, this is the unintended consequences of ideals. You know, lawyers operate in a realm where ideals meet reality. That's where we operate. And what we're seeing now is the investors that are coming in are what I would call opportunists. These are people that know the risk, but they're saying, in order for us to assume this risk, we have to have a substantial discount. The margin has to be large to justify our getting involved.
Sure.
The margin has to be there to justify paying Enochs' firm to help us navigate this regulatory sphere, or to pay off a tenant to get them out of the property, or whatever the case may be. And so that now you're seeing, but those discounts come at a detriment. Who are they a detriment to? The property owner.
Homeowner, yeah.
The property owner.
Yeah.
The property owner. And the property owner, I can't tell you how often we have property owners that come in and they say, here's the problem that I have. We look at it, we go, holy moly. Okay, you've been sued, so that you now got a time deadline that you have to start meeting. You're going to have to start writing checks, and then all of a sudden they get stressed. They get stressed by the imposition of a deadline that they have to meet. They get stressed by the fact that a lawyer's asking them to write some checks.
Yeah.
And then they go, oh, I just want out of this problem. I just want to, and they take a discount on the sale of the property to pass the problem on to an investor.
Well, the reality is most people that are entrepreneurial and own one or two rental properties, I mean, they're hoping that that's just going to be some sort of stream of income in the future. You're not anticipating these big, giant unforeseeables that you're trying to make people aware of, because you don't even know what those are going to be. But the likelihood of it being substantial or substantial enough in their life to majorly disrupt their financial plan for their future is real. And so their panic is real.
Yes.
And so to solve that problem, giving up, right, I'll just call it giving up, because they have to literally throw their hands up, is the only reality is, okay, what is it going to cost me? Yes, this is going to hurt my future financially, but in order to get myself out of this hole, which is already so many feet deep, I have to sell. And the unfortunate reality is they have no leverage at that point, because if they don't have anything to save the home, all they can do is maximize whatever the house is left with in their bank account, which will be massively depleted in comparison to trying to fight it, to trying to go on, because it sounds like, with housing being a fundamental right, or however you're describing it in your exact words, the landlord doesn't have very many options if the rule of law, which is very clear, is saying that they violated it, and now they're in a horrific position where the only alternative is that massive discount. They get forced into that massive discount.
Correct. And if and single-family residential properties that have a tenant in the property, from a buyer's perspective, are less attractive than single-family residential properties that are owner-occupied.
Or vacant.
Or vacant.
Yeah, absolutely.
Yeah,
no, I agree.
Yeah.
And there's a lot that we can continue to go on with. We're well over a half an hour of content just talking about specific examples, and I know you have a plethora of cases, but most importantly, what I wanted to do was provide you with enough content, not scare you into not making decisions to buy rental property in California, but if you're going to decide to invest in the state of California, Mr. Enochs is the gentleman you need to reach out to, because what you don't want to do is make assumptions. What you don't want to do is shortcut the process, because the shortcut to cutting in front of that line today, when that karma finds you in the future, it's apparently a very expensive ordeal to remedy what you could have figured out today. And for someone to just reach out to you and hire you for a small consultation initially for, I'm buying this property, I want to rent it out, what do I need to know? What does that look like on your behalf? Or what does a consultation for a future landlord look like, just so that people can understand it's not about ruling out investing in California, it's about doing it right, and then having someone like yourself that's a professional in the minute, right, with everything you mentioned. You're not waiting for laws to change and then find out.
Right.
You're finding out as laws change.
The way we approach things is, my background is business. I used to work in banking. I used to work in credit and collections within banking, used to handle foreclosures, got involved in purchasing portfolios of non-performing real estate secured loans. I understand the business aspect of real estate investment. So what I'm sensitive to when a client comes into our office and they're contemplating purchasing a property in California, I start off with a discussion about margin. What's the margin? What's the margin you're trying to achieve? What's the minimum? What's the upside look like? And we start looking at the margin. Now, when you're talking about margin, you're always going to talk about costs. So what we do with them is we help them anticipate what those costs are so that they can preserve the margin. What type of price do they need on the property in order to get the margin that they're looking for? How do they protect against these contingencies? Reality has a way of teaching people lessons they otherwise didn't want to learn, and we try to make sure that they're not surprised by what's coming down the pipeline and that they're prepared for it, all the while protecting their margin. if the transaction, once they get into it and they start looking at it, it doesn't seem like it's possible for them to protect their margin while picking up the property at whatever the negotiated price is, well, then they have a decision to make as to whether or not they want to take on the risk of having to sacrifice a portion or all of their margin. And that does happen. That happens all the time. And so we start off with a margin discussion, and then from there, it depends upon what they're negotiating. From there, if everything works out, then we can get involved in helping them paper the transaction and navigate the acquisition of the property, as well as resolving any legal issues that they're taking on associated with the property. And they do. They take on the problems that come with that flow with the property, and the investors have to be mindful of the fact that the wrongdoer, the property owner, especially if it's a mom and pop, they typically don't have the money to reimburse them for legal fees. So you're not going to have you're effectively not going to have any recourse, and so the cost of solving the problem is going to rely on them. It's important to know what that is so they can make sure that they're incorporating that in their analysis when buying the property in order to preserve their margin.
So with so much valuable content in a short period of time, what I'm telling you is, as a real estate professional, as a broker associate with my broker's license, that doesn't mean I understand all the nuances of what's going to happen in landlord-tenant law, what you need to do as far as all the disclosures that need to go out there. That really does become an attorney question, so that you can make sure that you're fully protected, and these are things that I now disclose, right? As everything kept changing, you start to realize myself as a professional, that some things are beyond my scope. Right? You go to a doctor, you get an assessment, they're going to send you to a professional if something comes up, and that professional in real estate is Mr. Enochs. So how can people find you, so that as they watch this content and go, I need to call you,
Enochslaw.com. It's ENOCHSLAW.com. We're the Enochs Law Group. We're happy to help.
I hope you found this as informative as I have. And this is the type of valuable content that I want to bring out, just so that I can demonstrate not everyone in real estate goes about the business the same way. I always try to figure out, what don't I know? How do we have valuable experts talk about what your reality may look like depending on what you're looking to achieve? And then also having such valuable content that you know who the expert is that you need to reach out to when it comes to real estate law of any kind. We were just talking about landlord-tenant, some of the things that you might run into, but of course there are multiple different scenarios that are real estate related. And are you doing other things with fence problems with trees and all of those different things? Like, how vast does your law practice in real estate go, so that people know exactly why to reach out to you for what scenarios?
We get involved in easements, we get involved in real estate secured loans, lien issues, title issues, ownership disputes amongst owners. It just runs the gamut. When we get into neighbor-on-neighbor disputes, it really depends upon the nature of the dispute as to whether or not it makes economic sense in order to get a lawyer involved. So if you're upset with your cat, the neighbor's cat coming onto your property and doing its business in the sandbox, okay, that's probably not going to make economic sense. However, if there's a water intrusion or a support issue that jeopardizes the foundation of the home, okay, yeah, that might be an issue. Now, I will tell you that's a topic for another day, but the ADU issue is creating all sorts of substantial legal disputes between neighbors, and we're starting to see more and more of those, and they are substantial in nature. And so, we because our clients come to us and they're taking on whatever legal problems exist on the property, we see a wide range of legal problems. It just runs the gamut. A lot of failure to disclose issues because investors are now getting involved. Investors are purchasing properties through single asset LLCs, in which they close down within a few years, and so there's not any practical recourse on failure to disclose. So we see the whole gamut. Now, we do represent lenders. We do represent lenders on real estate secured loan transactions as well, and we are starting to see an uptick in foreclosure activity.
Remember you mentioning.
Yeah, there's some uptick there.
So as you can see, you can reach out to Mr. Enochs for just about anything that's real estate related, including lending issues as well. So I really appreciate your time. I'm going to make sure that everybody understands they need to watch this entire interview all the way through, because there's so much content, so much information. And in an interview, I normally do a lot more talking than this, but the content is so valuable that I'm being a sponge right now, because even though I've absorbed all of this, it doesn't mean that I'm going to be able to grasp the size and the scope of what you and your practice have to deal with on a daily basis. So really appreciate you reaching out, reaching in, whatever you're doing, however you're reaching, right? But whatever you do, make sure if you have a real estate challenge, please reach out to Mr. Enochs' firm, because as you can tell, he is an expert in real estate law. Thank you so much for putting time into educating the public and educating me as a real estate broker. Thank you.